I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Tuesday. Hope everyone's well. This is the best I've felt in a week. As you can see, I'm on video, so yay, we're making it. We're making it. Kick the crap out of whatever I had, and whatever wasn't attacking me, they should know better. Anyways, hope everyone's doing well. I've got a good Moorish sovereign citizen. I still don't really know if Moorish citizens are considered sovereign citizens. The whole umbrella still confuses me. Sure, the comments will, they'll help me figure that out. Anyways, let's get into it. It's really good. Also got a bonus Judge Stevens at the end, where Judge Stevens is just tired of bullies. He makes them pay. So let's go. Let's just watch some court. Before I hit the play button, you already know what to do. Do your jump kick backflips, like and subscribe. So I got. All right, let's go.
Jet. Congratulations, Milton Hens to be.
So two things here that are odd.
Real quick, I do want to say this guy he did call in on Zoom court first thing this morning. The judge said, no, we're not doing this over Zoom again. You got to show up in person. This is about 2 hours later. I was watching all day waiting for this. But the little 30-second tidbit he had this morning was just him. It's in the thumbnail. You can see the picture with his dark red hat and his bright pink ascot. Didn't match. So I felt like I needed to call him out on that. As you can see on the thumbnail. But that's where it came from. Didn't think we needed to see that. Now let's go.
Go. So on this bond, so today it looks like we just have his motions today. We don't have a sentencing. So we don't have a PSI completed then.
Correct. I'm still waiting for the referral from the prosecutor's office, so I don't even have a date yet, but he did come to the office completely.
Okay. All right. So Mr. Hensley, then I thought we had a sentencing date today. So it's just your motion today. So just like I have every time you're here, I got to go through these questions with you. All right. And I want to make sure we cover them. Yeah, go ahead.
My Honor, my name is Milton Hens to be.
Yeah, I tried to remember that. Hensley Bay. All right, go ahead.
And I come before this honorable court today to respectfully address a matter of significant importance related to the case at hand. I hope to present this statement with clarity and transparency. On the 8th of January 2024, my Honor rendered a judgment following the trial proceeding in this matter. Subsequent to the judgment, I, Milton Hensley Bay, filed an appeal with the Michigan Court of Appeals. The appeal has been accepted and is bears a claim of appeal number 369382. I am compelled to inform this court that I am impelled to inform this court that in the light of ongoing appeal process, I find it necessary to request a stay of the proceeding in this court. The decision of the Michigan Court of Appeal will likely have a profound impact on the direction and resolution of this case. Furthermore, Your Honor, I must express that during the trial, my request for a continuance was denied, hindering my ability to adequately prepare for the proceeding. Thus, compiled with my current indigent status, present substantial challenges, I am unable to afford the costs associated with obtaining additional transcripts, filing experiences, and even basic living costs as I navigate through this appellate process. In consideration of my indigent status, I respectfully request that the court waives the bond option or any bond requirement in this case. The financial constraint the financial constraints I face make it impractical for me to meet the financial obligation associated with posting a bond. Waiving the bond requirement would ensure that I can effectively participate in the ongoing legal process despite my financial limitation. I humbly move to this court to enter in order to stay the proceeding in consideration of the pending appeal with the Michigan Court of Appeals. My Honor, I understand and comprehend the gravity of this request and assure that the courtroom that it is made in the interest of justice and the fair adjudication of my case. I am grateful for the court's attention to this matter, and I am prepared to provide any additional information or clarification deemed necessary by the court without self-incrimination. Thank you for your consideration, Your Honor. Respectfully, Milton Hensley Bay.
All right, so Mr. Hensley, I do have to ask these questions again, so they're gonna sound familiar to you. So you've got this motion before the court scheduled today. You do understand that you have a right to have the assistance of an attorney at any stage of the proceedings. This is another stage of the proceedings. Sir, are you waiving your right to have an attorney? You continue to want to represent yourself, or would you like the court to appoint an attorney?
I'll continue to represent myself.
Very good. And then you understand that if you can't afford a lawyer, the court could appoint one for you. Would you like the court to do that?
No.
Okay. You understand that the charges that have been brought against you and now that you've been convicted of, those are serious charges. They, again, are the charges of, let me pull the information here.
All right. While there's a long conversation. This is Judge Schaefer, as you can see. I am pretty sure this is Michigan. Someone asked where this was. And Ardo, yeah, this guy's actually very respectful when it comes to the court, at least in not interrupting, not pushing his agenda. He doesn't fold on anything, but he is actually respectful in letting people talk. Not very much drama in this case, besides the fact that he's a Moorish citizen. But yeah, this guy is respectful.
All right, count one is carrying a concealed weapon. That's a 5-year felony and/or a $2,500 fine with mandatory forfeiture of the weapon or device. Count two is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony and/or a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement. And finally, count three is felony firearm, which is a 2-year felony. However, it's 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, along with mandatory weapon forfeiture of the weapon or device. So again, do you understand the nature of those charges and the maximum penalties, sir?
I comprehend.
All right. And as it relates to count three, that's worth some, I guess, a special acknowledgement. We've talked about this previously, but that charge by itself requires the court to sentence you to 2 years in prison, which you would have to serve before you would begin to serve any sentence on counts 1 and 2. Do you understand that?
Comprehend.
And knowing that, you still wish to go forward representing yourself.
I represent myself. Yes.
Very good, sir. Do you understand that there's risk of representing yourself?
I do not understand.
You understand that there's risk of representing yourself because the other side is represented by attorneys, and the court will be required, as I have throughout the proceedings, to hold you to the same standard as an attorney, and the court couldn't give you any special consideration or assistance, if you will, with your motions or defense or anything of that nature. In other words, I have to treat you the very same that I would the other side, and they're represented by attorney. Do you understand that?
Hernan versus King said you can't treat me as a jurist because I'm not one.
All right, so we did go through that. You did raise that motion earlier. Court has a different interpretation.
We actually learned this from Judge Slavin. He can treat him as a U.S. citizen, even if he's a Moorish citizen. Remember, I'm going to butcher. It's the Sundry Act. The Sundry Act? I think that was what Judge Slavin said. where every Moroccan citizen is treated the exact same as a United States citizen. So he can treat you that way. And he's going to.
Interpretation of that case and what it meant as it relates to pleadings and not actual motions or trials. But do you understand, though, that you could be at a risk of by representing yourself, and that you are not going to have the training, the experience, or the education that the other side does? Do you understand that?
I comprehend.
Okay. Do you understand that I have to require you to follow all the rules and the same requirements that apply to lawyers in this courtroom? You understand that?
I don't understand that.
Okay, so I just went through this. Do you want to represent yourself? The court has to treat you the same as the attorneys. I can't give you any special help or relax rules or something like that simply because you're representing yourself. Do you understand?
I comprehend.
Very good. That's a long way of the court saying I can't give you any special treatment if you want to represent yourself. Do you understand that? Okay. Would you like the opportunity to either hire an attorney or just talk to a court-appointed attorney before we keep proceeding today?
No, we're not.
And then do you agree, if we go forward with your motion today, that you'll follow all the same rules that the attorneys and anybody else appearing in this courtroom are going to be subject to?
Comprehend.
Okay. Mr. Butler, do you have any questions regarding his waiver to counsel?
Thank you.
All right, you believe the court's complied with MCR 6.005?
I do.
All right. So as far as the court is concerned, Mr. Hensley Bay is represented himself from day one in this case. The court has tried to run through all of the questions that have been provided by SCAO to trial courts as sort of guidance, if you will, for those representing themselves and wishing to represent themselves. Mr. Hensley Bay has been consistent in his desire, his right, if you will, to represent himself. I find that remains the case today. Again, the court asking these same questions multiple times of him. And when we do this, I don't mean to insult Mr. Hensley Bay's intelligence. It's just something the court is required to do. And it might, from his perspective, seem like, why do you keep asking me these same questions? I want to represent myself. I have a right to do that. And you're correct, but we do need to do this each time, at least this court's interpretation, each time that you appear, because you certainly have a right to change your mind too. You want to hire an attorney or ask for court-appointed attorney, we can do that also, and then delay the proceeding until you retain or have a court-appointed counsel appointed. All right, so I do find that your waiver today, again, is knowing, intelligently, and voluntarily made. I would characterize it as unequivocal. Again, Mr. Hensley Bay has been steadfast in his desire to represent himself. I believe the court has, and Mr. Hensley Bay has also acknowledged the dangers of self-representation, that he'd be held, in essence, to the same standard as anybody else, court rules, rules of evidence, those types of things. And therefore, the court will then allow Mr. Hensley Bay then to proceed today. He has a motion before the court to stay the proceedings pending appellate decision. Now, this is one of those things, again, comes up when folks in representing themselves. He has filed his motion, scheduled it on for today, it appears. But he's also filed a claim of appeal. At least in this court's opinion, that claim of appeal is premature and that Mr. Hensley Bay simply has not been sentenced yet. So to the extent the court has one here in front of me, a claim of appeal that appears to bear his signature and was dated January 16th, that's not something the court would consider or can consider, at least in the court's opinion, because he's not yet been sentenced. Now, this is something he certainly can file post-sentencing, but that leaves us then today to the motion that was filed, which is simply a motion to stay the trial court proceedings. Mr. Hensley Bay, is there anything you want to state this morning in support of your motion to stay the proceedings, which would mean, in essence, the sentencing date that is, I don't know that we have a date yet, do we?
No.
That will occur at some point in the future.
One thing I have to add, John, is what I just read to you.
Okay.
The motion to stay, granted that everything been done, cases over with the Court of Appeals. They gave me a number. and everything, so the case is active. And I just ask that you, give me a motion to stay where we can get everything in order, because I also paid for the transcripts, and I was told it'd take, maybe 3 months before I can get them. So I just, mercy the court to give me that time, render that time to get these things in order.
All right, then Mr. Butler, what's the people's position on Mr. Hensley Bay's motion to stay?
So, Your Honor, I did receive a,
Welcome, Irish Demon. Very good to hear that positive news on Limey. Very happy to hear that. Irish Demon is in the UK right now visiting Triggered Limey. So yeah, that's great news. Glad to hear that. I don't know really what else to say. Hope I was gonna say hope you made it safely. Clearly you did. Hopefully you make it back safely, and send all of our prayers to Limey. But yeah, bud, take care.
motion, I suppose, from the defendant. It looks like sometime in maybe January. And it's titled motion to stay court proceedings pending appellate decision. And it is 3 pages in length. Last night, I received an email about 7:25 p.m. from someone other than the defendant, Curtis Sean Joseph Bay, sending an email, it appears on behalf of the defendant, with an amended motion for stay of execution pending appeal. Did that get filed with the court?
I've not seen it, no.
Okay. So I suppose I won't address that then. Then just looking at what.
It was filed on the 22nd.
So, but Mr. Hensley, that raises a different question I'm concerned about. So you've consistently represented that you want to represent yourself. This would sound like this is a third individual that's filing something on your behalf?
No.
Is that correct?
Yes.
Okay. Who's the third individual?
You told you it's Curtis Bay.
Curtis what?
Bay. Sean Bay. Yes.
Curtis Bay. So is that a relative of yours or something?
Yes.
Okay. Is he an attorney?
He have information.
All right, but he's not an attorney.
That's my knowledge. No.
All right. So because it's not been filed with the court, certainly Mr. Butler has raised it, court would not consider that today.
No, it's been filed. It was filed on the 22nd.
I don't
That's
have
right,
that. We'll have it, hold on, we'll have Mr. Geiger, our clerk is going to search for that. But even if it was filed on your behalf, if it's not an attorney, and you've indicated to the court you want to represent yourself, courts can't consider that anyway, all right? Because a non-attorney cannot represent you. You can represent yourself, or you can have an attorney represent you, but you can't have a non-attorney that's represent.
According to my nationality, Moorish American, we have counsel. And that's how we do with counsel.
Yeah. Well, I'm not aware of a court rule that would allow the court to have a non-attorney practice law. So that's a bridge we can cross, I guess, if and when we get it. But then, Mr. Butler, I would like you to address Mr. Hensley Bay's motion to stay the proceedings.
Thank you. Then just focusing then on the January 10th motion that was filed. The defendant doesn't give any rational basis for the stay of proceedings. There's no citations. There's nothing, no court rule, or case law, nothing like that cited. What the defendant does cite is Rule 6.004 in regard to speedy trials, which is wholly applicable to this case altogether. The defendant is not in custody. He's not an inmate, a prison inmate. It just does not apply. And so with that, we would ask Your Honor to deny the defendant's motion based on lack of merit, lack of grounds.
All right, Mr. Hensley Bay, I am going to deny the motion for stay. Mr. Butler's correct in reviewing what you have filed here. And it's a 3-page document. The third page is just a signature page. It looks like there is no grounds that has been cited that the court could rely on that would make sense for a stay. Now, you certainly still have a right, I'm going to deny that, but you certainly still have a right. You can file a request to stay the proceedings in the circuit, in the appellate court. There is a mechanism to do that where you could then also ask for an expedited review of the same.
I've done
But I don't know that I'm aware of that, other than you're indicating you have, and you have filed this thing called claim of appeal, which again, this court does not believe is appropriate because you've not yet been sentenced. In essence, I think what you want to do is you want to have a adjournment of this, or a stay of the proceedings, if you will, to have the court review something that is not yet right, which is the outcome of your trial. And it's not yet right because you've not yet been sentenced. So I'm going to deny that motion. I'm going to ask Mr. Butler to prepare an order that says your motion to stay the proceeding is denied. Now, if you do file something with the Court of Appeals and they grant your request for a stay, they would inform the trial court that the proceedings have been stayed.
Can I get that?
And then we would go from there. What's that? All right, so
I don't disagree with this normally, but this Mr. Bay is being respectful of the court, even though he's kind of wasting their time. He is doing what he believes. I mean, we can get into it. We can get into this conversation all day long, but because he's respectful, because he's not over talking to anybody, he's not yelling, he's not raising his voice. He is filing his motions that, like I said, could be wasting the court's time. Because he is doing everything to the best of his ability, I don't mind the judge kind of, saying, "Hey, procedurally, this is what needs to happen." I don't mind that. Very few judges will do it. Judge Schaefer has a lot of patience, and we see it in all of his cases. He's generally very, very calm.
just for the record, so the clerk has just handed to the court a filing that occurred yesterday. It is titled Amended Motion for Stay of Execution Pending Appeal Bond to be Waived. It's 1, 2, 3 pages in length. That is filed by Milton Hensley Bay, and that appears to be were these other pages attached? Exhibit for a motion to stay.
I believe that.
Okay, so then there's a third page that says exhibit for a motion to stay, case information, case header, case number, Court of Appeals 369382. Second page is citing looks like the parties, Any County Prosecutor, and then Hensley, Milton, Joseph. 11604, it's or 24 incomplete filing, order appealed from trial court on the circuit court, and then my name is the trial judge. Motion waived, transcript was requested, defective holding file letter. All right, so that looks like, I guess it could be, it's a copy. This was filed with the clerk's office, maybe what Mr. Hensley Bay has been referring to, that had something up a moment ago. So it looks like maybe he did file something with the Court of Appeals. So if you did, sir, this court certainly will take direction from the Court of Appeals if they give us some sort of indication that they have stayed these proceedings, or they will give you additional direction along with the court, what they are looking at as it relates to this filing, whether they have accepted it, rejected it as being incomplete, or something of those.
Well, they said accepted it when they give me the number. That number you just read out there,
Yeah.
369.
Yeah.
382.
Mhm.
That was the number that when they give it to me,
Right.
the number is accepted.
Yeah.
So that's why I came when they gave me information. That's why I presented the information to y'all yesterday. And it was
Okay.
also presented to me.
So that's been filed with the clerk's office, but it doesn't change this court's opinion about the motion that was properly before the court today, which was a motion to stay the proceedings. I'm going to deny that. I'm going to ask the prosecutor to prepare an order that indicates something so I can sign it. And then you certainly can get a copy of it from the clerk's office so that we're all on the same page. Now, again, if this, meaning this filing that I was just handed, results in some sort of direction from the Court of Appeals that your case has stayed, meaning the sentencing date, that we're going to stay the proceedings and the only thing left would be a sentencing date, then certainly the court would follow that directive. But right now, I'm denying your motion to stay the proceedings. And then Ms. Bond, can you give us an update then? I have Mr. Hensley Bay here. What's the status of that PSI?
I have yet to receive the referral from the prosecutor's office, so we haven't even begun the process yet.
Oh, so I assume he checked in with you though after
He
his
did
trial date?
complete, yes,
Okay.
he did come following the trial and completed his packet. So
All
I
right.
do have all that.
So you'll be contacting him in the future to then complete a
Yes,
PSI?
correct, yep.
All right. Then, Mr. Butler, you'll prepare the order denying his motion here today.
Yes.
All right. Then, Mr. Hensley Bay, that just means that we'll stay on track for a sentencing date. I can't tell you when that will be yet. They're gonna contact me, probation will contact you to begin, or I guess not to begin, to continue is the way I would put it, that process of completing the pre-sentence report. As I mentioned to you before, once that's completed, then you'll get a copy of it. You'll have a chance to check it for accuracy, so you can let the court know when we come back for sentencing, if there's any information in the report that is inaccurate, then we can get those corrections made so we have accurate information on which to base sentencing. So,
Can you also give me a ruling on, because I also asked the court, because of my financial situation, can you waive some of the transcript fees and the filing fees?
so it was my understanding that the court already signed a waiver, didn't they? I thought you were given a waiver. Yes?
For court filings, but.
Oh, for court filings, okay, for transcripts. So maybe that was in here, I thought. Let's look at that.
He lost that.
Let's see.
I think Selena was holding on to it.
This might be the first time in my life I would say grilled cheese does not sound good. I love grilled cheese and tomato soup. It's one of my go-to lunches. It is the last thing I ate before I got sick. Had nothing to do with me being sick. I didn't have a foodborne illness. Obviously, I just had traditional grilled cheese and tomato soup, but it's the last meal before you get sick, so it doesn't have a good memory to me right now. Otherwise, I would say absolutely. Grilled cheese is amazing.
Who was?
Selena.
Oh, well, maybe she has it. We can
Grab it earlier.
talk about it now. Oh, here, let's see. All right, so this looks like this was filed on January 10th. All right, so the court does have it. So Mr. Hensley Bay, you did file a fee waiver request. You indicate you receive SSI. And you didn't fill out any additional information as it relates to income. So there's a box 3, your household income, the number of people in your household, your source of income. The court did review this on the 11th. It looks like at that time, the court denied it because I didn't have all the information, income information had not been provided. So if you want to complete this, I certainly would review it again today. So it's that box 3 if you want to approach. Thank you.
All right, JoJo, what kind of cheese? Everything else is replaceable. The type of ham, it doesn't really matter. The type of bread, doesn't really matter. What kind of cheese? That makes the biggest difference. There is a right and wrong answer to this question, just so you know, JoJo. Pressure's on. Leanne nailed it. That's the best answer. Cheddar and Swiss. Cheddar Swiss on a good wheat bread. perfection
All right,
every
thank you,
single
sir. So
time.
for the record,
Every
Mr.
single
Hensley
time.
has returned this to the court.
Steve getting fancy on this. I do like a good pepper jack.
Gross income of $1,900.
All right, move over, Steve.
Is that
Bu-
every week
Bubba
or
out
every
class
two weeks?
two.
No, that's once a month.
Once a month, all right.
Shit, what?
And the source of the income is the SSI.
This is the,
Mr. Hensley, it's curious to the court. When I'm looking at my notes from the trial, you indicate you're on this supplemental income, Social Security, if you will. I guess not supplemental, Social Security. But the testimony from both the 404B witness from the prior incident you had in Grand Rapids and then this incident, if I recall, you were driving a newer BMW. You might have been driving a Mercedes with the incident in
and it was my vehicle.
Grand Rapids. Whose vehicle was that?
It was for Sarah.
What's that?
It was the BMWs for Sarah.
Okay. Did you have a different sort of income back then? No.
The Range Rover, the Range Rover was 2011. Older model vehicle. Somebody I knew, somebody I was affiliated with kind of helped me.
Okay. And then the other thing that's troubling to the court, as I'm handed this and you've finished filling it out, I think my administrator indicated you came in and paid cash for your transcript already. Is that accurate?
Yes.
Okay. So is the cash part of your $1,900 a month?
Yeah, man, I'm depleted. That's man, I'm 50 years old, so everything I had saved, man, that's what it was.
All right. So here's, I guess my question, I don't know this. Do you know, was that the amount that was provided by Mr. Hensley Bay? Is that the full amount of his transcript or is
Estimated full amount.
that's estimated full amount? All right. Well, here's the issue with that. Mr. Hensley Bay, my understanding of the court rule is the fact that you are receiving Social Security makes you eligible for a waiver. So I'm going to sign your waiver. I'm going to redate it today. I'm going to check the appropriate box, cross these out. Just got to know Social Security. Today would be the 23rd, 2024. And then I'm going to check cash to be returned. Now, if you want to use that to hire an attorney for your sentencing date, you're welcome to do that. You're welcome to continue to represent yourself. Do you have any questions about anything?
Just gratitude for what you did.
All right, so I'm gonna give this to my court staff and I'm gonna ask you to step over to the clerk's office or not, the circuit court office, which is right outside this door. You can.
Pseudo, no one know right now is in Judge On's courtroom. He just sent me a message saying that I need to jump over there right now because there's an amazing hearing going on. He didn't even know I was live. That's where no is right now. That guy, he has no affiliation to anybody but, the courts. So, yeah. Jump over here right now. Funny.
Talk to my administrator. What I'd like you to do is I'm going to have her drop a piece of paper. You both can stand there and count the cash, and then you'll acknowledge that I don't know what the amount was, but whatever you gave to the court is being returned to you. I'd ask that you sign and acknowledge that. All right.
Okay. Gratitude.
Okay. They're going to contact you, meaning probation, to finish the PSI, and then once that's done, we'll give you a new sentencing date. Okay. I apologize. I thought this was the sentencing date. You do need to be in person for the sentencing date. If this was just a motion, had I known that, I would have let you appear remotely. But I thought you were here for sentencing. All right. So I know that you appear for your court date, so I'm not concerned about that. Mr. Butler, anything else?
No.
Okay, you're all set today, Mr. Hensley.
You have a order for me? You have a order for me? Deny the motion.
All right.
No, I don't, my option to print it, prepare to print it.
I'm gonna wait for them to bring it to the federal court.
Okay, yeah, that's fine.
All right, and then we're going to continue with our docket. So you're all set
Okay,
today.
gratitude.
You're free to wait. Mr. Butler, what else?
All right, do we have Javon Flair here?
Oh, we do.
Let's go ahead and call that case, people be.
All right, and here's the bonus clip of this video. Judge Stevens does not. Oh, this, you know what? I already gave the 10-second intro to this clip before the video started, so we're gonna play it without me saying too much. Also, we are going to be rating Johnny after this, which he's not going live for 40 minutes. Oh no, he said 2, not 1. Oh, I cannot go that long. I was thinking it was 40 minutes from now. He's going live in an hour and 40 minutes. I'm sorry, Johnny. I cannot go live that long. Cannot do it. I'm sorry. Well, we'll play this one. And then we might court jump for a little bit.
Bro, thanks.
So, Summerlin. We now call 23 CR 1125, the state of Texas versus Lenny Nixon. You are Mr. Nixon.
Yes, sir.
And you are here with your attorney, Mr. Lane, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? And can we proceed in summary?
He does.
In summary, the indictment alleges that was handed up by the grand jury on August 9th of 2023, that on or about June 25th, 2023 in Jefferson County, Texas, he committed the first-degree felony of aggravated robbery. Do you understand what you are charged with?
Yes, sir.
If convicted, you face a term of life imprisonment
Okay.
or any term of not more than 99 years or less than 5 years in prison. And additionally, you may be assessed a fine up to $10,000 if you understand that.
Yes, sir.
An agreement has been reached. You would be pleading guilty based on deferred or unadjudicated probation. This can be in up to 10 years in length, fine $500. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with this first-degree felony of aggravated robbery, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this alleges? Yes, sir. Yeah, did this then and there, in the course of committing theft and with intent to obtain or maintain control of property, you intentionally and knowingly threatened or placed a person in fear of imminent bodily injury or death. And you used or exhibited a deadly weapon, namely a firearm.
And Your Honor, we've gone over, there are co-defendants and we're pleading guilty. We are a party. We aided, abetted, solicited, or comforted others. So,
In what way?
well, there another person that was an older gentleman stole the gun from that guy, and Mr. Nixon was actually standing apart from them, and then he walked back around, and that guy gave the gun to Mr. Nixon. And that those other guys were older than him, but they were all together. It's all on video surveillance. They were older, and that's why I think Mr. Ham was given the offer. I think they're.
It was co-defendant who was also given this very same offer.
That's correct. But it was the co-defendant that actually stole the gun and pointed the gun. Mr. Nixon did not. They just handed off the gun to him. So I think he would be more as an accessory to the fact. Yeah.
Just wait till Judge Stevens talks at the end of this. Every one of you will be happy. I promise. Yeah, okay, I'm not going to promise. Some of you might not be happy. 99% of you will be happy. Let's do that.
Okay, it says multiple black males were wearing ski masks with guns and took his gun. Was he wearing a ski mask?
He wasn't.
Is that right?
It's all on video, yes. Every bit of it is absolutely on video.
Okay.
Your Honor, this is,
What did he knowingly and intentionally do wrong?
He took the gun that he knew was just stolen off the guy.
Was he with the group of guys?
Well, they were all standing right there by the. I'm answering for him, but he.
I know, but we're talking about first degree felony, you know.
I understand, you know.
my understanding is it was a party, Your Honor. And that's why the offer of notice is Mr. Ham's case, and he's in drug court. The notes in my review of the file was
And this was just days after his 17th birthday.
It says, okay, in the complaint, it says investigation and video surveillance reveals a group of males, including Nixon, waited for the complainant to exit the store before stealing his gun out of his pocket and pointing multiple guns back at him. Nixon then received the gun from the male that initially took the gun from the complainant. All that true?
He did not point a gun at anybody, Your Honor. It's hard to describe, but it is actually.
Was he with the group though, waiting for?
He knew the
With the group.
friends, and
Okay.
they were sitting there. The other
Okay.
three persons had masks on, and he went over
I
and
guess
spoke.
the question is, why would you do such a thing? Anyway, over a gun? Really? And you were how old now?
I'm 17, sir.
Mm-hmm. When did you turn 17 before this event?
June 8th.
Uh-huh. This occurred on June 25th.
Yes, sir.
Are you kidding? You couldn't wait to become an adult so you can be involved in a crime involving a firearm?
Jeez.
That's
People I
terrible.
was around,
That's a
sir.
terrible way to start adulthood, isn't it?
Yes, sir.
Your Honor, he does work. He is participating with IEA, and his mentor is here and present. He's got a monitor. I've been in close contact with his family. He can successfully complete this probation. He is a non-violent person.
That's not according to this indictment, he isn't.
I understand, Your Honor, but his involvement is what I said.
I understand, but it still doesn't, you made a bad choice,
Yes, sir.
which is what seems to happen all too often in this room. How do you plead to this? Are you pleading guilty voluntarily and because you are indeed guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that?
Yes, sir.
You all Beetlejuiced them. No, I am going to play that cat video right after this one. Hopefully it's not taken down by when this is finished. So I have it bookmarked and we're going to jump right over to it after this. It's a really good one from the 30 seconds I saw. It's hilarious.
Harold, did you understand it? Discuss it with your attorney? So the content's all true and correct.
Yes, sir.
State's Exhibit 1 is tendered into it.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
All right, State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report, well,
It is by the.
they're good. Anything else to add?
No, Your Honor, we're just asking the court to follow the.
If not, I'm going to find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. A felony that would follow you the rest of your life, where you're facing life imprisonment as a potential punishment. Even though there's sufficient evidence to find you guilty, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation which are normal and customary for this type of offense. I guess you were arrested in this. How long did you stay in jail?
1 day.
How did that work out for you?
I don't want to go back.
Well, as a condition of probation, I can place you in jail for 6 months, day for day. Do you understand? That's what I'm going to do. This is a crime of violence, and far too often people make bad choices. But right here, aggravated offenses, violent crimes of violence are going to be dealt with. You know better. And people are tired of being victimized by a group of thugs like you were part of. You made a bad choice. Put people in fear of their lives.
Your Honor, we would ask that you suspend the 180 days. I don't think the guys actually stole the gun.
Yeah, let's be soft on aggravated robberies. No. I can appreciate where you're coming from, but no, we're going to set examples here. People are fed up.
You know, he does have an ankle monitor.
Okay.
That's something that can be removed.
Yeah, we'll have to do that. Are you in school too?
I graduated.
Okay. No, it's a terrible place. It's a terrible place. I can't imagine.
He is working.
1 day, much less 6 months. Do you see anything unfair about this? Nobody wants to go to jail, but you brought that on you with a bad choice and running around with a bunch of other people who make foolish choices, robbing people, stealing guns. Let me tell you, you're old enough to kill somebody by foolish behavior or hurt people. Okay. All right. I just want you to know we're taking firm stances and we're setting examples. We're tired of it. This is just the kind of stuff that's you think would be in somewhere else, but too often it's happening here. That is all. Thank you. Come here, Dennis.
All right, we're not leaving just yet. I'm gonna attempt to share my screen. We're gonna have some IT with Irish Demons tech support right now. Let's figure this out. But I got more court to show. Let's see. What is this court called? It's this one. Yep. If I hit share, blow it up. Let's go.
Okay.
Let's go.
You have court, okay?
Okay. All right. So are you Espinosa?
I think I did it right.
My maiden name.
Okay. So let me ask you a question. Do you have like a phone number where somebody can call you to let you know if you have to come to court or talk to your PR bond officer?
Do you want my number or do
No,
you want...
I'm not hitting on you. I just want to know because if I let you out on a PR bond, if I let you out on a PR bond, you're gonna have to call your PR bond officer. So if your PR bond officer wants to talk to you, do you have a phone number?
Judge just said I'm not hitting on you.
It is the fakest number anyway.
No. Here's what's gonna happen. Is I think it's gonna ask you for your phone number, and then you're gonna be released later on today. Okay, you're gonna have to call him in a few days to go on orientation. But I don't want to keep you in jail if I don't have to. I just need to make
Oh
sure.
no, I know exactly what my number is, and it starts with 915.
Stop. Ms.
Oh no, I
Geraldine,
know what the bus is. I already made it up.
all right, Ms. Geraldine, go ahead.
Thank you, Judge. Ms. Espinosa, what's your number?
My home address is where my cat Trinity is.
Oh, your phone number.
Your phone number.
Oh no, she can get it from that.
This is so they let you out.
Yeah, Trinity. Just spell Trinity.
Do you have your phone number, ma'am?
915.
Is that your home address?
233 on Murchison.
Do you know your phone number?
I told the idiot that if I had any trouble, I would just call 911.
All right. You know what, Miss Lambert, officer, we're done. Send an email to someone, tell them this lady is pretty bad mental health shape. Perhaps they can decline the case, okay? Right now, you know what, let's just do a PR one, administrative, admin, no, commit no new offenses, and report as instructed, although I'm not counting my cookies on that one, okay?
I mean, hopefully that gets declined.
Yeah,
because
hopefully, but to send a note to someone, tell them she's in real bad shape. I don't think this is probably something.
I'm
worth
gonna go with
pursuing.
there's nothing anybody can do.
Yeah, I think it's gonna be more expensive to prosecute the case and to probably cut it loose, okay? All right. Okay, everybody.
Your Honor, are you ready for the FFJs?
Yes, ma'am, bring him out. Everybody else is excused. Okay.
Thank you, Judge.
All right,
No. Was that it? You gave us a clip that was only 10 seconds long. Oh, I was hoping it was going to be a couple minutes. All right, we're going to court hop for a little bit. You guys want to court hop for a little bit? Yeah, I love Judge On. Is it on? And I don't know. It's AUN. But he's awesome. Let's court hop for a little bit. See what else we got out there. Let's see. Remove that. Hey, now back to just me. Let's see. Stop sharing. What court do you guys want to watch? I've got about 14 tabs open right now. Let's just pick one. Go back to Judge Stevens, see if he's still going. Is he still going? He is.
Okay. Brittany,
Yes, sir.
come on
All right,
up.
let's go.
Josh, with that. Stand up.
We can go to Boyd if you guys want to. You guys tell me what court you want to go to. This isn't live, by the way. I'm about probably 30 minutes, 40 minutes behind on this.
Joshua Ledet,
I am not a Cromwell.
better not be here with an aggravated
I am
robbery.
definitely not a Cromwell.
Right. That'd be a bad thing. Okay, 23 CR 969 is called you were Joshua Christopher Ledet. You just
No,
have to speak out.
I'll get in trouble for that.
You were here with Ms. Holmes, your attorney, and the state's attorney. You're charged with aggravated assault with a deadly weapon. That's not a good thing at all, is it? No. And what are we going to do today? It's an announcement.
We're going to ask for a little more time. This is Mr. Ham's case, and Mr. Levitt needs some more time to complete his financial
How
obligation.
much time? 6 weeks? Is that 6 weeks?
Yes.
Okay, we'll reset this 6 weeks. Mr. Brown, you can go. Did you get your resetting? Oh, you need to sign something over here. Thanks. And then I have. Ortiz?
We're ready. We had a issue with the interpreter, but thankfully Jennifer, secretary, agreed to translate.
Yes.
Then we call 21-37203. The state of Texas versus Jose Francisco Ortiz Rojas. That's you? Yes, sir. And Mr. Crenshaw is your attorney. The state's attorneys are present.
You know, I love
understand
Judge
the
Clark.
Defendant is not fluent in English. That is correct. He's fluent in Spanish.
Oh,
Yes,
okay.
sir.
All right.
And,
Yep.
we're going to,
Nope.
have a court interpreter call.
Nope. I'm sorry, guys. Interpreter cases, they're important, but I don't know. I get bored with them. They take too long. All right. I'm going to go look for Judge Clark real quick. I do not have him up. And no one knows said he's up, so we're going up. All right. Give me two. Found him real quick. We're going to. Oh, Judge. All right. We're going to rewind this. Judge Clark is doing. This is looking good. It's looking good already. Forgot I have to share my screen. You guys are not watching what I'm watching. No! No! He knew it was coming. We're striking out miserably in court hopping. All right, we're just going to pick one now. Did someone else have a different suggestion? So Judge Stevens was, let's see, what do we got? These civil probation ones are kind of fun. Let's see what they're doing. Let's see what the civil probation hearing is. All right, take away no one knows. Treason. Yeah, I know, right? Treason. Take it down right when I start watching. All right. Let's see. This guy. Yeah, we usually got drama. We usually have drama in this one. People talking, or people generally without attorneys trying to do small claims matters. Skip ahead a little bit. There we
Mr.
go.
Fox?
Yes, ma'am. I just wanted to say one or two things towards some of the
I actually
let's see what we got. I'm kind of running behind today, so I'm in the mood for granting continuances, but let's just see, okay?
Yes, ma'am. Thank you.
All right. Rhett versus Fox.
Yes, ma'am.
Rhett. All right. Somebody said something. One more time.
Yes, ma'am, Mr. Fox.
Where's Miss Rhett? Tawana Rhett. Okay.
I was muted. I'm sorry.
Okay, what's going on?
I called Ms. Marshall earlier, letting her know I caught food poisoning, and she told me I had to wait to get my case, be here to at least let you know that I am sick. Is there any way of doing the continuance today? Because I'm really sick. I'm throwing up and everything, and I don't want to describe anymore, but I really feel
what it depends on what's the issue, Miss Rhett?
I brought Mr. Fox back because he's picking and choosing the things from your order that from when we came the last time, he's picking and choosing what parts of the order that he will follow. He is, for example, the visitation that's supposed to be every other weekend. I might get a call 30 minutes before or no call at all. I've sat at the CVS waiting on him and not even shown up. So I don't know how to plan for my other child and things that I may have going on. I don't know until last minute or not at all that he's not coming to get the child. He had 3 visits in December and he got none of the visits in December, which altered, and this was the holidays, this altered how I was spending our time with our family and everything like that. Also, Mr. Fox has not paid. The order said that I was supposed to give the account and routing number for him to pay the child support. And he, I gave it to him twice via the text messages that I shared with the court and with him. And he still has not paid anything towards that. And even with those text messages I've shown where he's using the courts as his a pawn in his game.
Dude has an advertisement behind him as his Zoom screen. This is amazing. This is actually really smart. I love this idea. Can't see what company it's for, but start saving today, and it gives you a code. Guys, if you want to start saving today, no idea what you're saving on, but maybe it's Waffle House hoodies.
He has asked me if I was to drop the support, he would not move forward with the change of the name and adding his name to the birth certificate.
Okay, have y'all had a continuance in this case before?
No, ma'am.
All right, so it looks like these are matters that I can reset. So I'm gonna reset them since Mr. Fox is indicating he is not doing well this morning. So I will reset this one. Let's see. Hold for a moment. Let me see. I can try to get it. Maybe we can put it on for tomorrow or Friday. Give me 1 second and I'll let you know. Ms. Marshall, give me a call.
Yes, ma'am.
It's like the first week in February, so it's still it's reasonable. It's within 10 days. So we should be and it's not going to take us that far out. Mr. Fox?
Yes, ma'am. I just wanted to say one or two things towards some of the allegations that were just said toward me.
No, Mr. Fox.
Okay, no problem.
Either we're moving forward or we're not. Which one is it?
We'll just, like you said, we'll take care of it in the next 10 days or so.
All right, y'all free to leave.
Oh.
I just realized I was not unmuted. Yeah. That one wasn't too exciting. Next one.
Yesterday was a complete tight day. I couldn't even think about doing. In fact, I didn't.
And then you asked us to come back on the remaining contempt issues.
Oh, remaining contempt issues. This one looks good. Stop spinning. Just stop spinning. All right. We'll let this one play until Johnny starts. That's what we'll do. Hopefully he starts by the end of this clip. Where no. I got a good one that I've already grabbed. This one? I got one where a guy is claiming a woman hit his car and he was claiming property damage and he already got a judgment and she was denying paying him because there was no proof of it. That's what I got from this channel earlier.
Now we're moving to McAllister versus Eccles.
No. If this is about child abuse, I'm stopping this. I don't want to watch that.
Good morning, Judge.
Morning.
Jessica Fagan for the petitioner, Taylor Macaluso. She's the mother in this contempt action.
And
Okay.
Damon Vivek and Suzanne Prescott are here for the defendant, Mr. Eccles.
How much time are you requesting today?
I think as long as we keep it streamlined, you might recall, Your Honor, you heard us on an urgent matter in November. This is the 9-year-old competitive gymnast. You heard from her gymnastics coach ordered the parties to continue in therapy for the minor child, and you issued an order saying that father shall refrain from screaming at the minor child during punishment. And then you asked us to come back on the remaining contempt issues. Father's
Okay.
Council and I have tried to resolve this. We're not able to. So my side, I announced 30 minutes.
And we would need
Mr.
about, yeah, if, assuming we're not addressing anything on the emergency, because there was already an order denying the emergency contempt, and we're just looking at counts 1 and 2 of the full contempt, 30 to 45 minutes for our side will be enough.
All right, so I'm gonna put it for an hour. Okay, great, thank you. Reynolds versus Williams. Reynolds versus Williams.
Yes, John,
Is
I'm here.
Reynolds present?
I'm here,
Your
Your Honor.
Honor. All right. Oh. Ms. Dix Miller, I can't hear you. You were kind of underwater.
Yeah. So this is here for the petitioner for Ms. Reynolds. She's also present.
You might need to go in and come back out. I mean, go out and come back in because you're choppy every word. I can hear you now, but every word, every other word is lost.
Okay. Okay. Now I said Ms. Martin, let her know I'm having some
Yeah, you're gonna have to go. You're gonna go out and come back in, maybe, or rearrange. I'm not sure, but I know I can't hear you.
Okay.
Ms. Marshall, do you hear the same thing from Ms. Dix Miller?
Okay.
Yes, ma'am. If she could log out and try it again.
All right. So it's not just me.
Okay.
All right. Thank you. I'll come back to you. Golston versus Golston. Oh, okay. So I see Mr. Rhodes and Ms. Golston. Let me tell you, yesterday, your matter was on the calendar. We called the calendar. Ms. Marshall reached out to you. I think she said maybe she had your cell phone or whatever. Anyway, long story short was that when you all did not appear, we had the hearing. And the court made a ruling on the hearing. I know you came in later on realizing or indicating that you had some clerical error and you wanted to be heard on that issue. Yesterday was a complete tight day. I couldn't even think about doing. In fact, I didn't end yesterday until 8:06 p.m. But anyway, the reason I'm indicating is that I have not signed the order, but I did make the ruling, and Mr. Horace isn't present to contest any issues that you might present. So I think it's best for you to probably motion for some for reconsideration, and then the court would have to take it up at that time because he's not here. So there's nothing really I can do. I understand your position is that was some type of clerical error on your part and you want the court to reconsider it. But I need you to put that in writing because Mr. Horace isn't present. You're on mute.
Good to see you, Craig. How are you doing, buddy?
Mr. Rhodes, I can't hear you because you're on mute.
Hopefully you're feeling better, Craig.
Absolutely, Your Honor. I'm here today begging for that permission to file that motion. That Miss Marshall emailed us the notice very timely. I forwarded it to my client immediately, and we both independently put it today, not yesterday. And I am so sorry, and I will file that motion.
I thought your client was present.
She is.
No, I mean, she was present yesterday.
Yes, ma'am, she was.
Oh, she was. Okay. Then it was just me.
She appeared yesterday, and then I called the calendar. She answered the call of the calendar. I told her I would be entertaining the matter in momentarily. Then when I called again, she was gone. She left.
Okay.
I don't know if you heard that or not.
No, I called her as soon as I got out of my hearing. I had that message from Miss Marshall, and I called her immediately. And
no, she was on before. Before that,
Okay,
because it was the first thing I did was I called the calendar and she answered it. So
Okay.
I don't know how, Miss Lewis is shaking her head.
No, I wasn't there.
You didn't answer the call of the calendar?
No, ma'am.
Are you sure?
Yes, I had set the my calendar. I don't know if I read it or saw it somewhere that said Tuesday. I put it in my calendar for that day because I have to put everything in my memory because I got a 7-week-old. So I was trying to put it in my calendar, and that's the day I put it in there for that date.
Okay, let's double check because somebody answered the call, and it could have been someone who understood or thought that they heard their name and answered it, and so that's why I thought you were present. So, and then left. So, yeah, that was why
if I may, so I won't misspeak. I believe Mr. Horace made a statement about paying child support for children that live with him. And then the opposing party stated that no, he was not paying her child support, even though he had the kids.
Yeah. So pull up the video and let's see who it was who responded, because Ms. Lewis, Golston, your position is it was not you, correct?
Yes, ma'am, that wasn't me.
Okay, raise your right hand. Do you solemnly right hand?
I'm sorry.
Do you solemnly swear or affirm testimony about to give to the court the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And Ms. Golton, is your position that you were not on, you did not answer to the call of your case on yesterday before this court. Is that your position?
Yes, ma'am.
All right, then. So we'll take a look at it. Go ahead, Mr. Rose, and file that motion. I thought someone answered the call and then left. So that will obviously make a significant difference to the court. Okay. So file the motion, and then I'll take it up at that time. Okay.
thank you, Your Honor, again, and my humblest apologies to the court.
All right, you all take care.
Yes, ma'am.
And yeah, Ms. Marshall, if you would pull that tape for me.
Yes, ma'am.
All right. Maybe get one more in. We're about to raid Johnny May, so that's what we're about to do. That's why I was jumping live for a little bit. Sorry, sharing my screen instead of using a video. But that's what we're about to
Also,
do.
Your Honor, we do
I'm just
have
waiting
one
for the
more-
green light to raid him.
Yes, thank you. Did Miss Dix come back through?
Did what come back through?
I don't see her in the waiting room.
Okay. Call her one more time
iPhone
because
just-
I'm about
An
to start
iPhone
this.
just came in.
Huh?
There's an iPhone in.
This is Mr. Williams. I've been in.
Okay. Miss Reynolds, open your mic. Let me see if I can hear you.
Yes, ma'am. Can you hear me?
All right.
okay?
Okay. So, all right. I'm going to give Miss Marshall, call Miss Dix. I'm going to give her 2 minutes. If I don't get her announcement, whether it's long or short, I'm starting with the Eccles case. So she has 2 minutes before I get started on that case, and she'll have to wait until I'm done, which is at least an hour and a half.
Yes, ma'am.
All right. 2 minutes.
You know, talking while muted doesn't usually help. The beauty about being behind is you can fast forward. But I didn't fast forward enough.
All right. We're going to start the matter of Mac
There we go.
Luce versus Eccles. Go ahead and open up your video. There we go. We're missing Mr. Eccles. Where is he?
I'm sorry, Your Honor.
Mr. Eccles, I think you have some type of background or screen on in celebration mode.
Yeah, that's what they're saying. I don't know what that is.
Johnny May just went live. Do you want to watch this one case and rate him, or do you just want to rate him now? I'll let this play. I'll let this play for a little bit. We'll watch this case. If this is the case about the child, though, not going to watch it.
I try to Google it, and
I'm not going to watch that without watching it ahead of time to make sure there's nothing bad in it.
like balloons or something. I don't see it on my end.
Yes, they're balloons.
Sorry, I don't see it on my end, Your Honor.
Okay, you don't recall putting that on your background?
Not unless my kids did. But
I don't
think
see any
they've been
balloons
zooming.
either.
Yeah, I have no idea. Do you want me to try to get off
got you,
here and
Bonnie.
get back on?
Mr. Eccles, if you go to Zoom and preferences and you go to background and effects, under the video filters, just make sure it's off. There might be something that's just turned on there. Try that.
Background effects, video filters. It's on none and none.
Okay, none for virtual background, none for video filters, and none for
Yeah.
avatars.
None for avatars. Yeah.
Okay. Weird.
I have no idea why it's doing that.
All right, well, let's go ahead and get started. Ms. Granite, just give me a few more minutes. I want to just make sure Ms. Dix Miller does an announcement that requires a mediator whenever she shows.
I'm here, Your Honor. Can you hear me? Is that better?
Oh, yeah, that's a lot better. What's your announcement?
I uninstalled Zoom and reinstalled, so that's why it took me a little bit. I apologize.
What's your time announcement?
15 minutes at the most, Your Honor. It's just a motion for attorney fees and for income deduction order.
And what about for you, Mr. Williams? How much time are you requesting in response?
It's just 15 minutes.
You're saying 15 additional minutes?
No, just fine. It should be fine.
You're saying total?
Yes, ma'am.
Okay, all right. So let me go ahead and I'll go ahead and entertain Reynolds versus Williams first. Mr. Granite, thank you so much for your service. You're free to leave.
You're welcome, Your Honor. Thank you.
All right, let me go. I'm sorry, Macalusa versus Eccles, but because your time as announcement is longer, I'm gonna take this up 15 minutes up first. All right, so go ahead. Let's say, let me pull this up. I apologize again. Normally before the calendars, I can read through my notes, but we couldn't get my notes up this morning, so I'm kind of shooting from the hip this morning. So it looks like you're saying that there is a motion related to attorney's fees.
Yes, Your Honor.
All right, then. All right, let's go. You may proceed.
Okay. Your Honor, we came before the court back on September 13, 2023, when I filed a petition on behalf of my client, Ms. Reynolds, or a motion for an emergency hearing and an amended motion for contempt due to Mr. Williams' failure to return the child back to the physical custody of his mom after a visitation based on false allegations of physical abuse. The court heard the evidence and concluded that there were that the court did not find at that moment that there was substantial proof of any physical abuse that was done by the child, and as a result, the court entered an order denying the Mr. Williams' petition for family violence on September 25th. However, the court did want to make sure that the court thoroughly explored the alleged allegations, and so the court did also enter an order appointing a garnet litem, however, at Mr. Williams' expense, and did find that Mr. Williams was in contempt. 30 days later, after Mr. Williams was notified that he'd be financially responsible for that garnet litem, all of a sudden the allegations he agreed that the allegations were false, they were no longer true. He signed a consent motion asking the court to rescind its order appointing the garnet litem, which the court did do on November 2023. And in the hearing back in September, the court did indicate from the bench that if their claims were found to be baseless, that the court would be entertaining attorney fees. And so that's why we're here this morning, Your Honor, because as a result, had I not gone through the extent of having to file this petition, bringing the this issue before the to the court's attention, Mr. Williams would have never returned his child back to the physical custody of Ms. Reynolds, as was the order of the court, as she is the primary physical custodian of the child. And as a result, she's had to incur attorney fees. And presently, her attorney fees are total $6,698.22. As part of my motion, I
Give me
have.
the number one time, please.
I'm sorry.
The number one more time.
$6,698.22. As part of my motion, Exhibit C, I did include her invoices from my office for October 2023 and November 2023, which total that amount, $6,698. Obviously, that does not include my time that I'm here before the court today, but I will waive that time. We're just asking for the $6,698. As far as my experience, I have been practicing for 14 years in the area of family law. My hourly rate is $350 an hour, which is common and appropriate for a person of my experience.
Can you put Exhibit C? Can you share Exhibit C? Let me see that.
Give me one moment.
All right, no, they're showing personal documentation. We're gonna end this now. Stop sharing. Sorry. That's why I don't like doing it live. You can never really tell what's gonna happen. Here, I'll put this link. If you guys want to continue watching this, I'll put this in the chat. There you go. There's the URL for that court that we were just watching. We are at timestamp. We are minus 251. So it's been going on for a long time. So 2 hours, 51 minutes behind the live chat for that. If you want to go finish watching that clip, you can do it. But when they start showing personal documentation on the screen, I got to turn it off. I'm sorry, guys. But let's head over to Johnny. See what he's doing. The Raid Lounge. Let's raid the Raid Lounge. And yeah, thanks everyone for coming. I will be doing something else later tonight. Might be a premiere, might be a live. I don't know. Haven't figured it out yet, but I'll do something tonight. If you haven't liked and subscribed already, please do so. Yeah, Bob. Thanks, Bob. That's how I always have to address you. Thanks, Bob. But yeah, Demon did say he's going to be going live later, so we can jump in on that. Yeah. All right. Well, let's go check out Johnny for now. Got to bring it back up the outro. Thanks, everybody.